5 seconds to go. Start. We once again clarify that in this judgment we have confined our analysis only to the issues regarding the validity and interpretation of the provisions of the 2002 Act referred to above. We have not dealt with any other issue involved in individual cases concerning 2002 Act, as the parties have been given liberty to pursue their other remedies before appropriate forum. Furthermore, we have de-linked the matters pertaining to other legislations and issues arising therefrom from this batch of cases for being proceeded appropriately. In light of the above analysis, we now proceed to summarize our conclusion on seminal points in issue in the following terms. The question as to whether some of the amendments to the Prevention of Money Laundering Act 2002 could not have been enacted by the Parliament by way of a Finance Act has not been examined in this judgment. The same is left open for being examined along with or after the decision of the larger bench, 7 judges of this court in the case of Roger Matthews. The expression proceedings occurring in clause NA of section 2(1) of the 2002 Act is contextual and is required to be given expansive meaning to include inquiry procedure followed by the authorities of ED, the adjudicating authority, and the special court. The expression investigation in clause NA of section 2(1) of the 2002 Act does not limit itself to the matter of investigation concerning the offence under the Act and is interchangeable with the function of inquiry to be undertaken by the authorities under the Act. The explanation inserted to clause U of section 2(1) of the 2002 Act does not travel beyond the main provision predicating, tracking, and reaching up to the property derived or obtained directly or indirectly as a result of criminal activity relating to a scheduled offence. Section 3 of the 2002 Act has a wider reach and captures every process and activity, direct or indirect, in dealing with the proceeds of crime and is not limited to the happening of the final act of integration of tainted property in the formal economy. The explanation inserted to section 3 by way of amendment of 2019 does not expand the purport of section 3 but is only clarificatory in nature. It clarifies the word and preceding the expression projecting or claiming as or and being a clarificatory amendment, it would make no difference even if it is introduced by way of Finance Act or otherwise. Independent of the above, we are clearly of the view that the expression and occurring in section 3 has to be construed as or to give full play to the said provision so as to include every process or activity indulged into by anyone projecting or claiming the property as untainted property would constitute an offence of money laundering on its own, being an independent process or activity. The interpretation suggested by the petitioners that only upon projecting or claiming the property in question as untainted property that the offense of section 3 would be complete stands rejected. Stop.